ओके। वेलकम। वेलकम आज के वेबिनार पे सभी को वेलकम ऑन बिहाफ ऑफ वर्किंग पीपल्स कोalition. This webinar is being organized in the context of many current challenges that are facing the domestic work sector, right from minimum wages to non-recognition in the law, which in a sense are बहुत पुराने problems है, but अभी नए judgments के कारण there's new light on these issues. एंड आज के वेबिनार का ये भी एक मकसद है कि हम इन मुद्दों के ऊपर डिस्कस करें। एक नेशन वाइड मतलब अलग अलग स्टेट से लोग हैं और चर्चा ऐसी चलेगी कि अलग अलग स्टेट लेवल पे क्या हो रही है, क्या रिस्पॉन्सेज रहे हैं इन सारे चैलेंजेस को लेके, और हमारा डब्ल्यूपीसी करके या अलग अलग यूनियंस अलग अलग संगठनाओं करके हमारा कलेक्टिव रिस्पॉन्स क्या है। ऑलरेडी बहुत सारे लोग ये कर रहे हैं इंडिविजुअल लेवल पे, बट कलेक्टिवली हमारा क्या रिस्पॉन्स रह सकता है। तो उसी के साथ आई इनवाइट इशिता टू इन टू बिगिन द वेबिनार and agenda to everyone it has been shared on WhatsApp, but we'll continue. Over to you, Ishita, please.
Yes, I think I'm audible. Yeah. Yes. So we will be starting today's webinar of Working People's Coalition, and the theme is domestic worker. The title, as you have seen, is Whose Labor Counts? Domestic Workers and the Law. The recent changes in the law, the labor codes, and the recent ways in which domestic labor has been introduced as an app-based work we have seen. So these are bothering us as to where we are really going. Now, the webinar is, of course, covering the rights-based, ethical-based laws, the legal framework, the regulations, which are not only necessary, but also the part of women workers' right. And domestic workers, as part of decent work, as part of working women's rights, has to be in the mainstream of these rights-based movement, as they form a huge mass of women workers. So we will move on with the following discussion points. I would request all of our discussionists to focus on the legal parts, the Supreme Court's refusal to accept the minimum wages, as well as the labor codes, how the labor codes are looking at the issues of domestic workers, and the national law for domestic workers is still to be understood and taken up by our country, looking at the gaps in the wage code, looking at the gaps in the occupational safety codes, in the labor codes which fail to protect the domestic workers and is not applicable to the domestic workers. So there has been, we will say, we will not conclude as a deliberate, but there has been an exclusion of the domestic workers. And digital blacklists, fear-based profiling. So within the app-based way in which the domestic workers are being recruited, the new recruitment basis of app-based domestic workers. So all these will be discussed. And then let's have a dialogue within each other from all states, from various parts of our of organizations, of many organizations. And all of you will speak for, I think, 5 minutes so that we can come back and have a discussion together. So this is the introduction to the topic. this is a topic which is of crucial importance, not only from the point of view of only rights of workers' rights, but also women's rights per se, and working women's platform. And so I think let us go to the first panel. The panel one is will be dealing with law, policy, state laws, and international standards. There have been international reports in the ILO for a long time. We have the conventions which are talking about domestic work, which has been talking about domestic workers in various parts of the world. There has been international standards, and India is a signatory to those international treaties and laws. But how are these being reflected in our country? So in the panel one, we have from Tamil Nadu Domestic Workers Welfare Trust, Senior Valar, Geeta Menon from Karnataka Domestic Workers Rights Union, and then Brother Varghese from Montfort Social Institute, Hyderabad. So they constitute the first panel, and the second panel, we would be looking at platforms, profiling, and criminalizations. We have Kiran Moghe from All India Coordination Committee of Domestic Workers by CITU from Maharashtra. Madhulika from Center for Labor Studies, NLSUI. Uday Bhatt from Maharashtra Rajya Gharelu Kamgar Samanvay Samiti. Rita Rahidas from Grihakarmi Adhikar Suraksha Samiti from Assam. And we have Advocate Gayatri Singh as the moderator, and with closing remarks by Siddharth Joshi. So this is how we plan the seminar. This is very webinar, but we will be looking forward to more discussions and looking into the different states. Some of the states have been working quite intensively with the domestic workers, and there are recognized unions of domestic workers. So I think let's go on to the first panel, and then after the first panel, we will have a discussion, a small Q&A, and then we move on to the next panel. I think so. The panelists of
So,
the
Ishita, I'll just,
yeah.
I'm Marina, I'll just do the context setting in 5 minutes and then we'll do the first panel.
Yes. So Marina will be doing the context setting, but the introduction is looking into the ethical standards, the legal standards, equality, and the rights-based questions of the domestic workers in our country right at this moment in the context of the changing situations. Yes, over to you, Marina, after this introduction. Yes.
Thank you so much, Ishita ji. Um, uh, I will speak in English and do some translation of into Hindi also, क्योंकि there's one comment because I know जब हम ये India level के webinars करते हैं, some people are comfortable in English, some in Hindi, तो I'll try and do both. ओके तो मैं जस्ट 5 मिनट में आई एम जस्ट शेयरिंग कि हम ये चर्चा अभी क्यों कर रहे हैं। 3 संदर्भ है मोटे तौर पे। फर्स्ट इज ये द कॉन्वर्जेशन या जो करंट अभी जो न्यूज़ में आए हैं मिनिमम वेजेस को लेके, दैट्स द फर्स्ट कॉन्टेक्स्ट। दूसरा है कि लेजिस्लेशन डोमेस्टिक वर्कर्स के लिए एक राज्य स्तर पे या एक सेंट्रल स्तर पे कानून के ऊपर जो चर्चा चली है पिछले 1 साल से, जो बहुत ही पुरानी चर्चा है। क्योंकि we know that there have been 17 attempts by different unions to pass a legislation at the central level, 17 attempts, but there's still not been success to have a national legislation for domestic work. And there was a renewed interest in doing something like this in 2025, but again, that has not happened. So that's the second context. And the third, जो तीसरा context है इस पूरे webinar का, it is the platformization of domestic work, which is basically the rise of Snapit, Pronto, InstaHelp और ऐसे platforms में एज इट इज डोमेस्टिक वर्क जो है कंप्लीटली अनरेगुलेटेड है, लेजिस्लेटिवली अनरेगुलेटेड है। और प्लेटफॉर्म, जब हम गिग इकोनॉमी की बात करते हैं तब हम किस तरीके से प्लेटफॉर्माइजेशन को देखते हैं, नॉट जस्ट फ्रॉम द क्रिमिनलाइजेशन पॉइंट ऑफ व्यू बट ऑल्सो फ्रॉम द पॉइंट ऑफ व्यू व्हाट हैपेंस टू लेजिस्लेशन एंड डोमेस्टिक वर्कर्स राइट्स इन एन ऑलरेडी अनरेगुलेटेड सेक्टर. So just to get into a little bit of detail with regards to minimum wages, in January 2026, there was a Supreme Court order, Torilal Sangam and others versus the Union of India, where the Supreme Court has dismissed this petition filed by 10 unions and associations on behalf domestic workers, where they have refused to recognize the fundamental right to minimum wages, which is actually a fundamental right under Article 23. So the Supreme Court is saying no to minimum wages for domestic workers, and the thinking behind that was purely pro employers, that if we the writing in the of the case says that if we do legislate and have minimum wages for domestic workers, which urban household will want to hire domestic workers? Now, that is I think we can all agree that is completely false because everyone needs domestic workers, and increasingly so. Data is also showing that urban households are increasingly hiring domestic work. So the whole point on saying we can't legislate on minimum wages is completely, it's a fundamental negation of labor rights. बट इंटरेस्टिंगली उसी महीने में जनवरी 26 में एक स्टेट गवर्नमेंट, कर्नाटका स्टेट गवर्नमेंट ने एक प्रपोजल दिया था टू हैव मिनिमम वेजेस ऑफ 23,000 फॉर एन अनस्किल्ड लेबरर इन जोन 1 ऑफ कर्नाटका. ऑफ कोर्स इट डिडंट गेट पास्ड, बट जस्ट टू से कि जनवरी में ही एक साइड पे सुप्रीम कोर्ट बोल रहा है कि देयर विल बी द फंडामेंटल राइट टू मिनिमम वेजेस फॉर डोमेस्टिक वर्कर्स is doesn't exist. At the same time, a state government is saying that we want to provide minimum wages for unskilled workers abhi at 23,000, which is much higher than what the central government is even saying with the labor codes, etc. Of course, Karnataka did not go ahead with it, and April 26 to March 27 के लिए जो minimum wages has state made is still 16,000. But it is an interesting debate to have had in the same month with regards to minimum wages for unskilled workers. दूसरा कॉन्टेक्स्ट जो है ये लेजिस्लेशन को लेके है, विच लाइक आई मेंशन्ड इज अ ओल्ड डिबेट इन इंडिया, एंड बहुत सारे स्टॉलवर्ड्स है इस कॉल पे जो बहुत सारे पुराने लेजिस्लेशंस में बहुत ही एक्टिव थे. The reason why it came to the front is because, as you know, the Ajay Malik case versus State of Uttarakhand 2025. There was a case of a live-in domestic worker who had been abused. And this case, when it went up to the Supreme Court constituted they directed the constitution of a committee to say can there be a desirability of a legal framework for the benefit, protection and regulation of domestic work. But usi judgment mein it was also written that domestic work is a source of gainful employment for many women in the country, and saying that because इतने सारे औरत इस सेक्टर में काम करते हैं इसीलिए हमें एक लीगल फ्रेमवर्क की जरूरत भी है. बट अनफॉर्चुनेटली ये जो 9 मेंबर कमिटी ज्यादातर करके सरकारी ऑफिशियल्स थे उसमें, उन्होंने जुलाई 2025 में अपना रिपोर्ट जब सबमिट की थी तब उस रिपोर्ट में कोई भी नेशनल लेजिस्लेशन की जरूरत नहीं है ऐसे लिखा गया था. और ये भी कहा गया है कि एग्जिस्टिंग लॉज जो लेबर कोड्स है ऑलरेडी प्रावधान है डोमेस्टिक वर्कर्स के लिए, इसीलिए केंद्रीय स्तर पे कोई जरूरत नहीं है एक नेशनल लॉ के लिए. Now, I just want to a little bit deviate from here. In December 25, there was a webinar organized by the Martha Farrell Foundation in December, में काफी सारे सिविल सोसाइटी रिप्रेजेंटेटिव्स थे, और उस वेबिनार में ये रिपोर्ट के फाइंडिंग सब पेश किए गए थे. और कुछ पार्टिसिपेंट्स जो वेबिनार में थे वो कमिटी मेंबर्स के साथ एक्सेस, मतलब उनका संपर्क भी रहा है. ज्यादातर दिल्ली बेस्ड ऑर्गेनाइजेशंस है, तो आई थिंक अ लॉट ऑफ द रेस्ट ऑफ द स्टेट्स जहाँ पे डोमेस्टिक वर्कर्स काफी एक्टिव है, वी डोंट हैव एक्सेस टू दोज नेटवर्क्स, ये वो द दिल्ली बेस्ड ऑर्गेनाइजेशंस that were in touch with the committee members. But one important point to make here is कि ILO के भी representatives थे उस कमिटी में, as per the Supreme Court a committee constituted by the Ministry of Labor and Employment. ILO की भी representatives थे उस committee में, but उस webinar में ILO के जो representatives थे उन्होंने ये बताया कि we have refused to sign the report क्योंकि हमारा राय नहीं लिया गया था इस report के बनाते समय, and it's also not, we do not support or we do not endorse the recommendations of the committee. तो just important to say कि committee के members भी सहमत नहीं है इस कमिटी के recommendations को लेके, तो there is definitely some scope for other civil society organizations to also, to say and to really participate and really negate the findings of the report. But while this happened, okay, ये हुआ कि no need, the committee report said no need for domestic workers national legislating. Simultaneously, again, Karnataka में 2025, late 2025 में, there was the domestic workers bill, the draft domestic workers bill that was tabled. That was open for public suggestion and objections. उसमें there is again a proposal to set up a welfare board, and of course हमें पता है in states like Kerala, Tamil Nadu, Maharashtra ऐसे वेलफेयर बोर्ड्स है, एंड मे बी कुछ जगह पे जैसे महाराष्ट्र में इट्स नॉट फुली फंक्शनल, बहुत सारा काम है उसमें करने के लिए, और बहुत सारे यूनियंस ऑर्गेनाइज संगठन काम कर रहे हैं उसको फंक्शनल रिस्पॉन्सिव बनाने के लिए। साइमल्टेनियसली आज के वेबिनार में असम, तेलंगाना ऐसे और स्टेट्स हैं जहाँ पे बहुत सारे लोग काफी सारे एफर्ट्स डाल रहे हैं उनके स्टेट पे एक लेजिस्लेशन और वेलफेयर बोर्ड की मांग करने के लिए। एंड आई थिंक एज डब्ल्यूपीसी हम ये रिकॉग्नाइज करते हैं कि ये बहुत सारे एफर्ट्स चल रहे हैं अलग अलग डिस्ट्रिक्ट्स में, अलग अलग स्टेट्स में, या अपने स्टेट लेवल पे लेजिस्लेशन और वेलफेयर बोर्ड लेके आने के लिए। बट कलेक्टिवली डब्ल्यूपीसी, क्योंकि हम एक इंडिया लेवल नेटवर्क है, ये एक मांग भी है कि एट द नेशनल लेवल देयर इज अ नीड टू रेगुलेट अ सेक्टर लाइक डोमेस्टिक वर्क, जहाँ पे इतने सारे महिलाएं काम करते हैं, महिलाएं ही नहीं बट ज्यादातर करके महिलाएं हैं, और किस टाइप की महिलाएं हैं, किस वर्ग से आते हैं, किस सोशो इकोनॉमिक बैकग्राउंड से आते हैं, वो तो हमें पता है, डेटा में हम ये सब देख सकते हैं। लास्ट कॉन्टेक्स्ट, ये जो थर्ड कॉन्टेक्स्ट है विच जो थोड़ा हटके है बट बहुत ही रिलेटेड है लेजिस्लेशन को लेके, इज द प्लेटफॉर्माइजेशन ऑफ डोमेस्टिक वर्क, विच इज बेसिकली स्नैपडेट, प्रोंटो, अर्बन क्लैप के इंस्टा हेल्प, ब्रूमीज, ऐसे सारे बहुत सारे जो इंस्टेंट डोमेस्टिक हेल्प को लेके आजकल एप्स बहुत हैं। एंड बड़े शहरों में, दिल्ली, मुंबई, बैंगलोर, पुणे, ऐसे बड़े शहरों में दिस कॉन्सेप्ट ऑफ प्लेटफॉर्माइजेशन ऑफ डोमेस्टिक वर्क की बुक करो 10 मिनट में कोई डोमेस्टिक वर्कर आएगी, बहुत ही कम रेट में, 50 रुपए के लिए 1 घंटे में जो भी काम आपको करना है। इट इज नाउ लुकिंग एट आर्ली वेजेस, नॉट टास्क बेस्ड वेजेस, विच इज वॉट द मिनिमम वेज notifications for domestic work, whichever states have it, they all look at task based, but अभी ये सब प्लेटफॉर्म वाले they are saying hourly based, हम डोमेस्टिक वर्कर्स का पेमेंट देते हैं। बट व्हाई इज इट इम्पोर्टेंट? वन इज एडवर्टाइजमेंट करते समय एक ऐसे प्लेटफॉर्म ने मतलब एडवर्टाइजमेंट करते समय दे यूजिंग दिस फियर बेस्ड कि डोमेस्टिक वर्कर्स जो है ये क्राइम्स कमिट करते हैं, तो आप हमारे पास आइए, हमारे जो भी डोमेस्टिक वर्कर्स है जो हम प्रोवाइड करते हैं, वी विल हैव पुलिस चेक्स डन। कुछ जिन लोगों का क्राइम्स है सपोजिटली, उन्होंने वेबसाइट पे उनके चेहरे मतलब उनके फोटोज के साथ डाले, विच इज रियली बैड। मतलब ऐसे इस तरीके से किसी भी डोमेस्टिक वर्कर का ब्लैकलिस्ट करना या विदाउट वेरिफिकेशन ऐसे डेटा डालना पब्लिक डोमेन में इज रियली रीइंफोर्सिंग जो हार्मफुल स्टीरियोटाइप्स है प्राइवेसी को लेके। कुछ भी मतलब देयर इज नो कंसिडरेशन, मतलब डोमेस्टिक वर्कर्स आर जस्ट सीन एज अ सर्विस एंड नॉट एज ह्यूमन बीइंग्स। तो आई थिंक वन एस्पेक्ट वाज हाउ डू यू एडवर्टाइज these platforms, and the other and most important one is कि अभी इफ यू लुक एट जो भी डेटा आ रहा है, बहुत सारे डोमेस्टिक वर्कर्स ये बोल रहे हैं कि इट इज प्रॉफिटेबल टू जॉइन अ स्नैबिट, क्योंकि जितना वो पार्ट टाइम डोमेस्टिक वर्क में कमाते हैं अलग अलग घरों में जाके, they are able to earn much more on these platforms. They are able to earn 22,000 to 30,000. They have options, आपको 2 घंटा काम करना, 8 घंटा काम करना, incentives बहुत है, health insurance है। So suddenly it is becoming एक profitable for the domestic worker to join a platform, अगर उनके पास टेक्नोलॉजी का कुछ अंडरस्टैंडिंग है। दूसरा, एज एन एम्प्लॉयर इट इज वेरी मतलब बहुत ही चीप है, 50 रुपए के लिए, 100 रुपए के लिए, 1 घंटे के लिए यू आर एबल टू हैव अ डोमेस्टिक वर्कर टू डू इतना सारा घर का काम। तो इट इज सडनली बिकमिंग वेरी प्रॉफिटेबल, बट दिस इज अ बिजनेस, एंड आई थिंक दैट्स रियली द क्वेश्चन वी ऑल्सो आर ट्राइंग टू एड्रेस कि जब ये बिजनेस का और प्रॉफिटेबिलिटी की बात आती है, जैसे हमने फूड डिलीवरी एप्स में देखे या कैब सर्विसेज में देखा है, जब तक ये इकोनॉमिक्स चलती है, वंस इट बिकम्स प्रॉफिटेबल, तब वर्कर्स को का जो आमदनी है वो कम होती जाती है, उनके जो इंसेंटिव्स है कम होती जाती है, द कस्टमर्स विल स्टार्ट पेइंग मोर एंड द इंटरमीडियरी जो प्लेटफॉर्म है वो ज्यादा कमाने लगेंगे. सो दिस इज जस्ट, मतलब अगर हम एक साल के बाद की बात करते हैं, व्हाट डज इट मीन टू हैव डोमेस्टिक वर्कर्स वर्क फॉर सच poor rates, which anyway in a country that is now not even saying कि minimum wages की जरूरत है, but अभी उनके पास ये apps है, they have to keep working, you know, you can't switch off your phone, कुछ days है आपको काम करने के लिए. तो it's really a sector जहाँ पे anyway no regulations है, legislative regulations है ही नहीं. Platformization उसको एक तरीके से just it multiplies all the vulnerabilities that domestic workers anyway have. So with this, this is just the context, webinar ka context. My request now is to Gayatri ji, who will be moderating. Advocate Gayatri ji, आप में से बहुत सारे लोग उसको उनको जानते हैं. She is a very well known advocate in the Mumbai High Court. वो trade unionist भी है, labor lawyer है. बहुत सारे मुद्दे पे she is the voice of people. And we really we are so glad, Gayatri ji, that you took you are part of WPC, but you have also been very instrumental in organizing this webinar. So I just want to acknowledge that. So thank you so much, and Gayatri ji, over to you to moderate the sessions.
Yeah, thanks. I'm trying to put on my, yeah. So I just, without much waste of time, because we have shortage of time, and the speakers who will be speaking are all very seasoned activists. So it's not just for a change, it's not lawyers who will be presenting any presentations, but basically people who are actively working in their field amongst domestic workers, who have faced many obstacles, particularly faced with legal restrictions, legal problems, and have been able to overcome these problems and establish strong unions of domestic workers. So I think each one's contribution will be very, very valuable in terms of how they see the problems and what is the step ahead. So I would just request the speakers to restrict, instead of going too much into detail in respect of the problems faced by them, to explain what the problem is in their area and how they see a solution to that, what are the remedies forward, both nationally as well as at the state level. So I would first introduce Sister Valar Mati from Tamil Nadu. She's been an active worker working amongst the National Domestic Workers Movement and the Tamil Nadu Domestic Workers Union. So the question that I would pose before sister is there is a law which has been enacted in Tamil Nadu. What are the basic provisions in the law which are beneficial to the domestic workers? How we can take advantage of that, and then how she sees that particular state level legislation taking an active form in terms of taking it at a national level. So, Sister Valarmati.
Yeah, good evening to all. So sorry that we don't have law for domestic workers. Okay. To tell you the truth, the government has not passed the law. So based on Tamil Nadu experience for domestic workers, so all of you know that from 1985 we have been filing different PALs to get things done by the government of Tamil Nadu. So first of all, the recognition came 1999 as a workers in Tamil Nadu. Then we have also got the separate welfare board through different rallies and petitioning and other things in 2004. When it came to the minimum wage, the government was not willing to bring minimum wage for domestic workers. Our union filed a PAL to the court in 2015. Then we got a verdict saying that the domestic work, the court gave an order to fix the minimum wage. So then we got in 2018 only the government has fixed minimum wage for domestic workers. From 2018, we have been taking different measures, okay, different actions to get legislation for domestic workers. We have conducted several conventions, rallies, bringing the officials, ministers to the forum, nothing more, okay, for the legislation. We have drafted the legislation and we have submitted to the different bodies, Labor Department, CM, then the Law Minister, SC/ST Minister, Women Commissioner, Human Rights Commission, even the Human Rights Commission, Women Commissioner, they all have forwarded message to the government saying this sector is need to be covered by the law. Even with that, we have requested the government to bring a set of legislation for domestic workers, but the government has not responded. So lately, last year, we have filed again PAL to the government, the Madurai High Court, asking the government to bring the legislation. But the court also again directed the Labor Department to look into this matter. That's all they have given. But still, it is pending. We are unable to not convince the government. Really, it's like adamant. I don't know what to say. How to the Labor Department is worst. That's all I can say. In spite of several efforts, several petitioning, still they remain very silent to the issues of the domestic workers. That is the status in Tamil Nadu we are going through, but we do not know now. The election is coming again. The government will be changing. What will come through? It is a great challenge for all of us. It's but other than this, so this is regarding the domestic workers. I said in very short. When it comes to when you look at different unions that they have been filing PAL, in the country, like recognition of domestic work as a work, minimum wage, inclusion under law, labor law, protection from exploitation. I think based on all this PAL only, the Supreme Court has given the order, to the government to look into this, that we all are aware of it. But the committee report really, we all of us, as we have said, it is very, heartbreaking. That's all we can say. I don't know. The domestic work, which compose of 99.9% women, those who work in these sectors, they are putting them into other work because since other laws are covering, why do you want separate law? That is the conversation here people also ask. You have the Manual Act. Why do you want the separate legislation for domestic worker? That is the conversation Tamil Nadu government also asks. But keeping in mind the reality, the situation, the exploitations the domestic workers face, I think the government should take it very seriously. Even in the committee which they have formed, none of the member presented who are working for the domestic workers. Domestic workers were not included in the committee. The real people they are not included. Committee, someone favor of somebody, I don't know. No. That itself, it's a justice that I feel. I think that we as a unions, as organizations, civil society, continue to raise our voice against the government. I think really we need to continue that one. We need to make the government to take it very seriously. Even the labor code, they say it is covering. But when it comes to occupational health and other things, and nowhere domestic workers are included. Even home is not considered as a place of work. When they not considering the private home as a workplace, how they can say that they are included in the labor code? It's all this remains as a challenge for us in front of us. I think we need to raise our voice very strongly on these issues. Thank you.
Yeah, thanks a lot, Sister Valarmati. I think we'll go ahead. I'm not translating it. Do we need translation into Hindi?
I think we can do a summary translation later, Gayatri.
Later. Okay.
Yeah, keep to
So
time.
the next speaker is Geeta Menon. She's a well-known person working in Bangalore. She's the co-founder of Sri Jagruti Samiti and joint secretary of the Domestic Workers' Rights Union. She has been closely involved with women workers in the informal economy and has been at the forefront of community issues, domestic violence, and sexual harassment, as well as trafficking. She is the recipient of a prestigious Citizen Individual of the Year award by Nama Bangalore, the Nirbhay Award regarding women's safety and empowerment, and has been basically been honored with several local and national awards. She's a very active person amongst the has been working on with the domestic workers for several years. So I just ask Geeta to speak on. I would just focus on one issue, which is what in as far as Karnataka is concerned, what are the specific rules or policy decisions with regard to domestic workers, and how and you were also, your organization was also part of the Supreme Court petition. What do you feel the Supreme Court should have done? We know what they did, but what they should have done, and what is the way forward? Yeah, Geeta.
Salams everyone. Thank you, Gayatri, for this too long introduction. But I just would like to not take up too much time and focus on much of it has been spoken already, and we are talking in the context of what they have done to they have criminalized the workforce, as well as are trying to get trade unionism out of the picture. So, in this background as to what is happening in the country all over, and in the background of looking at domestic workspace through the intersectionality of caste, class, and gender, we have to pitch it there. So, just two aspects of what is happening in Karnataka largely. The first part of the first part is that yes, we were one among the 10 organizations that filed a PIL and had a simple mandate, that is to talk about the minimum wages that are there in the states that which they have been introduced, and why minimum wages have not been introduced in the other states. Just one simple mandate. And with that simple mandate, you all know the kind of response from Suryakant to that, and where he has eliminated domestic workers out of the whole picture, in the sense of that they don't deserve wages as a fundamental right. I mean, wages as a fundamental right, and also brought on the whole argument about the unions and unionizing. So we of course feel very betrayed. It's a big sign of betrayal by Chief Justice of India, who's taken an oath under the Constitution of India. So in this context, we feel betrayed, and we are just trying to get together to see what we can do in terms of working on this, on the issue of wages further. It is not to bring about another law or not to go back to the courts with the same thing. Anyway, the doors are closed there. So right now, as far as wages are concerned, I think Marina was mentioning about Karnataka, but as far as Karnataka is concerned and the minimum wage notification is concerned, we were one of the first states that in 2004 we had the first minimum wage notification. But even if you take it from there on, from the way it was framed, and from there on till today, it is an absolute, very, very weak understanding of the way wages have to be computed, the way wages have to be standardized, and especially for such a very dynamic workforce. A workforce which has different employers, different hierarchies of work, different tasks, different locations. So, but they put everything into one basket. And as with the government, There is no serious scientific study done before. So they had computed wages according to task, yes, but they mixed up the cleaning task and the day and the care task together, in the sense that cooking, sweeping, swabbing, cooking, washing vessels was put, and no, not cooking. Washing vessels was put into one, and childcare was put into one basket, and they computed wages for that. The wages were computed not on the basis of the Raptor Coast Bread Agreement. It was just computed on the basis of tasks. But the tasks are not worked out on the basis of consumption patterns of the people or living standards of the people. I mean, not follow the Raptor Coast Bread Agreement at all. So it was very weak, and to which we had done studies and we had presented it before the government. One thing I would like to mention here, which is quite strange, was when they started the minimum wage notification, they did not include cooking in the first stage. And then when we pointed it out, they said, then you give us a list of 100 people who are working at cooking. And then after we gave the list, then cooking was included in the minimum wage notification. So this is one of the strange things happened. And as you know, the governance or the labor department and the labor ministry is, it thinks about domestic workers is the last. In any case, we are put on the last hierarchy, on the hierarchy of work as the last. And the thinking among the government, as well as in the mindset of people, is that domestic work is not work. So continuously we have to prove ourselves that we are workers and not criminals, and what we do is work, is labor, and it is productive. On this premise, what we have been fighting all these years, and today, of course, the Karnataka minimum wage notification has at least bettered itself to about 20,500, which was in 25. 20,500 was in 25, but there they did not include, and it was for the divided by zones. So the urban areas it was one, and the districts it was another. Now, why we find it very, very imperfect and very low as far as urban locations are concerned. As far as districts are concerned, sometimes we can apply this notification and fight to get proper wages. I'm not saying it's a magic wand, but strategically we were using it. One is that we should be included in the database. Second is that we have a weekly day off mentioned there. Third is that in the districts where they were getting lower than the lowest wages, we could use this notification for whatever legal effect it has. The alter part of it is that many complaints did not come up under this as minimum wage complaints, because the workers were very scared that the next day the employers would take them out of their jobs. So we were having some discussions with the labor department about what protection can we ensure for any domestic worker who comes and complains. But in another aspect of this, under the Payment of Wages Act, we were able to take up cases of live-in migrants. You see, so that framework for the live-in migrants did work to some extent. But as you know, with the kind of judicial speed that is there, we had to abandon it halfway, and the domestic worker got whatever she got, which was very unjust. But this is the framework in which Karnataka is functioning today. For a long time, it's like a fact that there is an act, there is an act, there are minimum wages prescribed, but the entire employer setup is such that this kind of monitoring or enforcement that has not been seen to. So everyone pays according to their whim and fancy. So we are just fighting with our union and with talking to the domestic workers and fixing up, continuously talking about a wage rate card and trying to see if we can at least have a minimum benchmark beyond which we cannot do much, beyond which the domestic workers themselves have to negotiate. Many cases they are negotiating themselves. So while on one side we have this very sort of almost legal framework of wages for domestic workers, on the other side it's being taken away today by what the Chief Justice of India says and by what everyone in the country considers as not necessary, and by what the apps are doing today, by how the apps are functioning in terms of wages. And it is just a glorification that they're getting 25,000, 30,000, which is absolute rubbish. They are the dictates of that, the dictats of that economy are very different from what is happening in the regular domestic work sector. That is one part of it. The second part of my presentation here is that if you take the about the legislation part, we have been for long with the national level, whatever has been happening, and the legislation at that end. The stage of the legislation at that end. In 2025, when the Supreme Court judgment had come, when the same Suryakant sat and said that, and gave this adesh that an expert committee be formed in different states in order to talk about legislation. And we know now what the expert committee report is all about, which is all about not supporting the domestic workers. But it was at that time, after repeated emails and repeated going personally and giving out about the judgment, asking about the judgment, asking about the experts committee. It was at that time in July, August, we decided that our union decided that if the government, if the Supreme Court order is not being followed, also we need not sit quiet. We should start working on a draft legislation for the state. I was only interested in the state legislation. So we started working on a draft legislation for the state, started getting groups of domestic workers together to start thinking about it, to get their inputs on it. Everything we had started. In the meantime, National Law School really came in and their students really helped us. And along with the students and along with the Law Center for Law and the National School, we had a consultation with the government and other stakeholders. This was in August. In August, when we had the consultation, we have been having various representations to the Labour Minister and to the Labour Department here. And from June 16th, we had intensified the protests and the appeal to the Labour Department and Minister. And we had also put in as to what we would like as a task force to be set up with a nodal authority, so that there is a separate domestic worker task force. And we had also put in registration, what are the issues that we want, about grievance redressal, about all this was already there on the plate. The Labour Minister at that time, after we had the National Law School consultation, where very good recommendations were given as to what could come into the law, the minimum provisions that could be under the law, the Labour Minister and the department decided to, and they brought out saying that they have finalized a draft bill which was not in Kannada, a draft bill which was not there was no consultation with the people, with the workers involved. First of all, it was not in Kannada, so therefore, how do you expect lakhs of people, domestic workers themselves, to get involved in it? The other thing was, it was not referred to any of the groups or any of the unions for any review. So after fighting for that, to have a public consultation on their draft bill, the government held a public consultation on their draft bill. The draft bill that they had prepared had many of our recommendations, and we were quite okay with the way the registration was implied in that, with the way the grievance redressal was mentioned, with the way the regulation of wages was mentioned. All that was okay. We still had a lot of feedback to do, and which we were getting into. But what happened?
Geeta, can you shorten it?
Yeah. I'll just end this with this. So what happened is, on that review, on that, the government refused to listen to anyone. And the government went with then put up the draft bill in the public domain. But finally, what has come out is, even that objections that came on the public domain has not been taken has not been shown to any of us, and the government is trying to do it on their own. So, in a big flurry, they announced that they're going to place it before the cabinet, and they did not place it in the assembly session at all, but they have placed it before the cabinet. Now, what is the most frightening thing is that when we had a look at the revised draft bill, we are seeing that the objections that came in from the employers, and the new draft bill has no responsibility placed on the employers. There's no responsibility in the employers or the government, and the domestic workers have to bear the entire responsibility as well as the penalties that are there. I mean, it's an absolute weak bill, and we just cannot agree to it because occupational and safety health standards, nothing is put there. Plus, they have put the thing on wages as referring to the code of wages, which again there are problems. They put social security as referring to the code of social security, which again there are problems. So, what we are trying to say is that this is the most undemocratic way that a bill is trying to be pushed through, a draft bill is trying to be pushed through in Karnataka without the consent of the many lakhs of domestic workers. So this is where we are at, and we are trying now other strategies, that is to get in the Women's Commission into it, and to also talk about with other unions. We are trying to talk about how to get many more responses added to the bill, and like Madhulika will be talking about, where the platform workers, gig workers were also not included in the draft bill. So I think I'll end here because time is short.
Thanks a lot. That was great. Very sort of educational also, in terms of we did not know the details of what has happened to the Karnataka bill. Thanks a lot. I'll ask Varghese Thekkanath to speak. He is the director of Montfort Social Institute in Hyderabad and has been an activist working in Hyderabad for several years, over 26 years. He's also the founder director of People's Initiative Network in Hyderabad, and also the Campaign for Housing and Tenurial Rights, known in short as Chhatri, in Hyderabad. So, Brother Varghese, please go ahead. I would just put a question to you. Maybe you could put that also in context. That is to say, since the committee that said that there is already an existing legislation, etc., the issue of decent work, what is meant by decent work, if you could speak on that, and relate it to the ILO Convention of 189 in the international context. How do we see our legislation, national legislation, the existing legislation in the context of the international ILO, which India has not ratified?
Thank you, Gayatri. One thing is that we have no legislation, no central legislation to begin with. I want to focus a little on the love-hate relationship that has existed between Convention 189 and the process that went to adopting it and the stand of India. Now, ILO Convention 189 was adopted on the 16th of June 2011. I happened to be involved in the process, also being present in the first discussion that took place in Geneva in the ILO on decent work for domestic workers. So that process and how India came to support it, and where it has, what is the tangent that the government of India has taken in terms of whether it will be ratified or not. So I just want to focus on that. Now, when you talk about, see the key rights, one thing is that the purpose of the Convention 189 is that domestic work is recognized as work. After ILO was formed in 1919, for the first time, domestic work, decent work for domestic workers was taken up. And the key rights that is included in Convention 189, it includes daily and weekly rest, limiting the number of hours of work, minimum wage, protection against abuse and harassment. There is a very stringent rule on the age limit for domestic work, and in the ILO Convention, it is 18 years of age. In other words, bans child labor. Now, if you look at India, see now, the ILO adopted or decided, the General Assembly decided in 2009 to take decent work for domestic workers as its focus area in the next, that is the 99th General Assembly of the ILO. Now, the first thing that came in was the, what you call the Brown Report. Every government had to formulate what is the status of domestic workers in their country and what legislations, what exists. So that's what the Brown Report. And this Brown Report, the Ministry of Labour, Government of India, sent that, in fact, to the NDWM. That was the most prominent domestic workers organization that was present there. And I happened to work with NDWM at that point as a consultant. And then I was given the task of preparing the reply that the Government of India will present to the ILO as its report. So we worked on it and then prepared the Government of India's status report on domestic workers. And then the next stage, then the ILO gathers all these reports of the different countries together, and then there is the final discussion when it comes, that is for the, in 2010, the first discussion took place, and that report is called the Blue Report. One thing that surprised me is that, see, now we had said in our report, the Brown Report, that India supports a convention. Convention has is international law. A convention to protect the rights of domestic workers. Now, in the Blue Report, that's the report that finally came up for discussion in Geneva in 2010. They had kept practically everything we had written, but just 2 words were changed. And that was, instead of that India supports, they had put India does not support. That was the only change that they had made. In 2010, the Assembly, the General Assembly, I happened to be present. There were others from India who were present. There were about, I think, 26 or 27 people from the Government of India, including all the ministers, the state ministers, secretaries, everyone was present. And as soon as the report was put up for discussion, India moved a resolution saying that we do not need a convention, but we need only a recommendation. These are the 2 possibilities, or 3 possibilities really, either convention or recommendation, or convention and recommendation. India said we need only a recommendation. And the whole morning we went through the governments, the representatives went through the voting process, and India cut a very sorry figure. Only a few countries, especially from West Asia, supported India. Otherwise, it was overwhelmingly decided that we will have a convention, in other words, a proper international law to protect domestic workers. So, in fact, and then what surprised is also that the entire government representatives that was present in the assembly at that point of time just disappeared. Right through the meeting, it was practically, I think it was 10 days or so, practically they disappeared, except for the last days when the General Assembly came up, where the minister, in fact, Karge, the Congress president at this point, he was the Labour Minister and he was present there, representing the Government of India. Now, when we came back, we made such a hue and cry, this was the UPA regime, such a hue and cry. We met Sonia Gandhi, we met everyone else concerned, so much so that Sonia Gandhi finally constituted a committee in NAC, National Advisory Council, that she was heading on domestic workers. And the Government of India decided to support that. India voted for a convention when the second discussion, that is in 2011, the discussion came up, India said yes. That's how India came to support the adoption of is a signatory, in other words. Now, ever since, that was in 2011, ever since, at least during the UPA regime, people working with the domestic workers, in fact, I run two trade unions here, the Telangana State Domestic Workers Union and the Andhra Pradesh Domestic Workers Federation, and also part of the network, other networks. Now, ever since, we have been asking the government of India, especially during the UPA regime, that India should ratify the convention. But India has so far, and the excuse that was given was that why India will not ratify is that we do not have a national law. So we said, okay, then why don't you adopt a national law? Because government's own admission, well, at that point of time, they had been talking about 4.75 lakh crores, 4.75 million domestic workers. But now the NDA has acknowledged that there are at least 30 million domestic workers in India. Now, that was the debate that was on. And then finally, a policy was adopted since 2011, after the convention was adopted. The task force of the Ministry of Labor had been working on a policy. In fact, I did the first draft of the policy. Very first draft of the policy, which was refined again and again and again. That was ILO was involved in that process. And in 2012, if I remember, we had a very good national policy that was. And then we were requesting the government at that point of time, please adopt this policy. But then, and it did not have to come to the parliament. It had only to be approved by the cabinet, the central cabinet. But we were told, in fact, we had met all central ministers asking that this policy is adopted. In fact, but then we were told, this is Mr. Pawar, who was a very influential minister, we had met him and then he had said he will support the adoption of the policy. But then in the final, when the meeting came up in the cabinet, we were told that he said if domestic workers are organized and unionized, and if they are given, if this policy is adopted, then every household, there will be a battle. And this is now, this is basically the problem why we still do not have a policy, why we still do not have a law. That it affects everyone, many of us sitting here. And this is something that we need to keep in mind when we are asking for a legislation. Well, now we are not asking for a policy really, whether it is at the state level or at the national level. Practically, the Supreme Court has said, now central government, you are not going to, okay, you go to the states and get your legislation passed. This is practically what the Supreme Court has said. Now, and then of course the NDA regime came, they set aside the first draft. As I said, it was a very good draft that was there really. But then that was not adopted. The NDA came up with an entirely new definition of domestic work, domestic workers, and the policy itself. The only thing that I found is good in it is that they acknowledge that there are at least 30 million domestic workers in India, and the largest sector. What's the status of this ILO Convention 189? As I said, India has done practically nothing as far as ratification is concerned. India is a signatory, but then there is the process of ratification in the international law, and India has not lifted a finger. At the moment, see, in fact, this convention came to the date of entry, came into force really on the 5th of September 2013. Now, 40 countries have ratified Convention 189. What surprised me is that if you look at the list of those countries, the only Asian country that has ratified Convention 189 is Philippines. No other country in Asia that has the largest number of domestic workers and is also the sending country as far as domestic workers are concerned. None of these countries have ratified. Most countries in South and Central America have ratified. Some countries in Europe have ratified, particularly Western Europe ratified, and some countries in Africa have ratified. In fact, many countries in Africa have ratified. And the last country to ratify is the Ivory Coast, and it is supposed to enter into force in Ivory Coast in April this year. So this is the status as far as the convention is concerned. Now there is See, India, when the last time India came up for the Universal Periodical Review, the Telangana Domestic Workers Union, there's the GUTS, Graha Karmikala Union, Telangana state, that is, we are facilitating, and also the Andhra Pradesh Domestic Workers Federation, these two trade unions. We did a study of the status of domestic workers, and we sent a report as an NGO report, a civil society report, when India came up for a periodical review 3 years ago, wasn't it? And one good thing that has happened after that, India, the Human Rights Council took this up, and the government of India has agreed that India will ratify Convention 189. This remains a promise, but this was a promise that was also made the previous time India came up for Human Rights Council review. In fact, I think in the 8 years ago, the previous time, at least 5 countries had asked the government of India to ratify Convention 189. India being the one country that has the largest number of domestic workers, as well as India being the largest sending country.
Brother,
Previous
could
time,
you?
yeah, I mean, I'll just close it. I'll just
Yeah.
close it. Yeah. India. So even the last time, India did promise that India will ratify Convention 189, but there has been no steps taken. Now, I have been wondering how we can use the promise that has been made by the government of India during the Human Rights Council review, how civil society organizations, trade unions, and organizations of domestic workers can really use this promise that has been made by the government of India, and how this can be brought into the state. There are still cases that are on in some of the states, as well as in the Supreme Court, or there are cases to be filed. How this can be used. Also, how else can we bring international pressure on the government of India to ratify Convention 189? So these are, especially India promising to be the Vishwaguru, wanting to sit in the high tables of the Security Council as a permanent member. Is there some way that domestic workers unions and domestic workers organizations can really work to ensure that India ratifies Convention 189, for which India will need a national legislation, India will need state legislations. So this is, I'm just asking this question, how can we do it? Thank you.
Thank you, Brother Varghese. That was very educational, again, I would say, because it explains the entire process by which India participated in the convention, from signing to not ratifying the convention. I will just conclude. We were originally planning to have questions and answers after this, but I will just summarize what has happened and then what has been discussed, and then we will go into panel 2, because time is short for panel 2. So I don't want to cut the discussion, as far as panel 2 is also very important. But I'll just summarize the issue pertaining. Why I said legislation is because today, according to the government, the only legislation that exists are the 4 codes. And they try to justify it by saying that the 4 codes basically are sufficient to cover domestic workers. So from a legal perspective, I didn't want to go into the law much, but from a legal perspective, even if we look like superficially as far as the definitions in all the 4 codes are concerned, there's absolutely no clarity as far with regard to who a worker is, because it is used interchangeably at times between a worker and an employee, and a domestic worker is specifically excluded in the IR code, which says that the industry, which basically the definition of industry is looked upon as that where there is business being engaged in, trade being engaged in, and occupation. Now the problem is that as far as occupation is concerned, whether it would fall within the definition of domestic services is specifically excluded in the IR. And I don't want to go into too much of details, but very clearly as far as the definitions are concerned. The definition of a domestic worker is excluded. It is only in the Social Security Code that the definition of domestic worker is included in a wage worker. However, a wage worker is seen as someone who is who where a domestic worker can be included. But what are the benefits that a domestic worker gets? From the Social Security Code, we see that it is zero as far as Social Security benefits and schemes are concerned, and that is because there is a threshold which has been placed on all the legislations. So all the four codes have a threshold limit where if the workers are more, if they are less than 10 or less than 20, then the Social Security benefits will not be applicable. So again, domestic workers are definitely excluded as far as Social Security Code is concerned. And as far as regulatory mechanisms are concerned, the IR code, which is supposed to regulate the labor employment relationships, basically again has a threshold limit which prevents workers, domestic workers, from being organized, from forming a union, from having any form of collective bargaining. And lastly, I would say, as far as wage code is concerned, again, wage code, as Geeta very nicely explained the whole aspect with regard to wage code. I don't want to go into it, but domestic workers are not covered under any benefits as far as wage code is concerned. And lastly, as far as social security, social health and occupational safety and health is concerned, all establishments where workers are working where there are more than 10 workers will be excluded as far as workers in smaller units are concerned. So basically in households also workers will be excluded. And lastly, I would just say that it is very essential that we look at the Convention 189, because 189 explains what a domestic work is, which I don't want to go into, but people should just look at the definition. It is so simple and so basic. And what a domestic worker is, which should be included in our new legislation, which means that any person engaged in domestic work with an employment relationship, which is how a domestic worker is defined, not in the context of occupation, not in the context of establishment, not in the context of industry, but in the context of employment relationship. And lastly, I would say, why is the government so scared of ratifying the ILO convention? Because the only six basic standards, which are parameters which are set out in the convention, are: one, protection of human rights; two, fundamental rights at work, which includes working hours, etc.; freedom of association; three; four, elimination of all forms of forced labor; five, effective abolition of child labor; six, elimination of discrimination; and ensure protection from violence. So these are the basic ingredients where any single worker should be protected, and where a specific law relating to these aspects should be covered. So I will end here and move on to the second panel, which is basically, we start with Kiran Moge, who is an active working in the C2 organization. And give me 1 minute. Yeah, she is the founding president of the Pune Jilla Ghar Kamgar Sangatna that started working with domestic workers in 2004. It is a registered trade union of domestic workers affiliated to C2 in Maharashtra. C2 has registered domestic workers unions in 10 districts and 12 states across the country. And there is an All India Coordination Committee, of which Kiran is the convener. Yes, Kiran.
Hello.
Please go ahead.
Yeah, but are you going to ask me a question or no?
Do I have the right to ask you?
Of course you do, since you asked everyone else.
So
Or
basically,
do you want
yes.
me to respond?
So basically, the session is on criminalization, profiling, and platforms. So if you could speak in terms of your organization, in terms of organizing domestic workers, what were the problems faced, and particularly pertaining to criminalization and the issue of sexual harassment at workplace.
Yeah. Okay. So, since time is limited, I'll focus one on the criminalization aspect. But if you give me 1 minute more, then I would also like to make a few suggestions of
Yes,
what
yes.
we can do in the future.
Yeah.
I think we're talking about criminalization in the current context, especially all these advertisements from the platforms, profiling, etc. But I think criminalization is not new to domestic workers at all. And anybody who's organized them in the past will know that accusations of theft are quite common by employers, particularly when they want to get rid of them. This happens when employers think that they would be obliged to pay, say, a Diwali bonus, or they want to um, uh, dismiss someone who's perhaps getting a little older and not being able to cope physically. So it has always been a strategy of employers to criminalize the domestic worker, and especially if they are not organized, then the the reaction would be to take them to the police station, vilify them, public shaming to a certain extent, and then the worker quietly leaves, and that's the end of the story. So we dealt with these kind of cases early on during our unionization by actually two methods. One is that we gave our members an identity card, with her address, with the union address, and the very fact that the worker had an identity and appeared to be backed by a union itself made a difference. And we saw that in many areas, then, if such accusations of theft were leveled to our members, other members would gather and they would collectively go, say, to the police station and prevent the case from being lodged against her, criminalizer, and negotiate with the employer, find out what the issue was. And in 99.9% cases, of course, we found that it was false, and either the gold or whatever money was found, or something or the other. There was another reason behind it. So our strategy was to collectively confront it, and the identity card and the collectivization helped. But I do believe that there's another aspect of criminalization which comes through the medium of discrimination. Yeah. And what Geeta was talking about, especially the caste angle, and even in these ads, the dirty part of it. So, today in gated communities, we find that domestic workers are not allowed to use common lifts. They're not even allowed to use common spaces to, say, have their lunch. They're asked to use separate entrances. And in a sense, this is demeaning, degrading. And this is an aspect, I think, that all of us as unions also have to bring on to our agenda. And when we talk about wages, when we talk about weekly off, we talk about all the other working conditions, we need to bring in this aspect of uh, discrimination, which I believe is really, almost just one step lower than the kind of criminalization that happens. Now, the third aspect is the criminalization which comes from the platforms. There, I think we are up against a challenge, because I'm not going into details, because many of us work in common unions where we know what the problems of gig workers and platform workers are. And I think the entire anonymity of the employer, the platform. Even in Book My Buy, we tried very hard, say in Mumbai, found an address of the Book by organization, but it was virtually impossible to even give a memorandum and negotiate
or even tell them that, we disagreed with what they were doing. So the anonymity of the platform would mean something entirely different. And I want to make one point here now, which is that, all the previous speakers and all of us, I think, are now at an impasse as far as legislation is concerned. And I think it basically flows out of a very deep institutional anxiety of the judiciary on one hand, and, very clearly expressed by Suryakant, the way he said it, about opening floodgates of, what is it he called, cases or whatever. But also, I mean, every time we try to negotiate it with the political class, with the bureaucrats, with the judiciary, we've always come up against this wall, about, what Father Verghese was also talking about, that, somehow either domestic workers will misuse the law, or, there will be this floodgates of cases. And I think it really comes out of the fact, as he said very correctly, that they all see themselves as employers. And so, in a sense, in their minds, they're applying about what would happen if the law came in and they were forced to pay domestic workers minimum wages and give them all the benefits that other workers would get. And I think this whole elitist class approach is something that we are up against. And I don't know how actually we are going to be able to beat it. So my suggestion in this is, one, I think we need to make this political class and these bureaucrats aware about this. And I think we really need to go to the mass of domestic workers. If I may say so, we all work with organizations. We all have a certain set of members. But the number of domestic workers in this country is far beyond what we are in contact with. And can we, through this meeting, come to some conclusion about whether in the future we can really have this mass campaign where we take this issue of how domestic workers are viewed by these people, and in a way have some kind of a signature campaign or something which actually addresses the Supreme Court, not to appeal and say to them that, oh, we want a law, but actually to bring to their attention that we as workers are not happy with the way that they have typified us, stereotyped us, and that we want a law in this country, and that we are there for it, and that we are going to struggle for it. I think somewhere this message has to go both ways. It has to go into the domestic workers, the massive domestic workers on one hand, and it has to reach the others. So can we strategize that? That's one point that I wanted to make. The other, that yes, we have common platforms, but I don't think they're common enough. I think we're still working a bit in silos, and I think we need to dialogue much more and come to some common conclusion about what we can do. Can we have, for instance, public hearings in different states or even different cities, for that matter, where we can come together? But I think unless we have a common strategy now, we are not going to be able to make this breakthrough. I think we have been doing this for the last 25, 30 years. And I think we are up against a wall. It's a difficult situation, a difficult moment for domestic workers in this country. So how are we going to make the breakthrough? I don't have many ideas, but I just think that it's something that we all need to discuss. The third point about platformization. I think we should be concerned, but honestly speaking, what is the extent of platformization? We need to be more careful. I mean, some of us feel that now platformization is here to stay. It may be, but I think it still has a very niche kind of demand. Most employers also, whatever the issues that they have, would also prefer to have what shall we say, a permanent kind of a worker with whom they are culturally also comfortable with. So having a platform worker whom you don't know might be good enough for coming in for a small task, or when your usual domestic worker is on leave or there's an emergency situation. But I personally don't think that platform workers are going to sort of take over the entire domestic work segment. And there is another reason, which is the supply side of it. The image of the platform worker that is being pushed, and to a certain extent, the kind of domestic worker who will be able to meet the requirements of a platform is a much younger, smarter, mobile phone savvy kind of a person with a certain set of skills. Whereas if you look at the mass of domestic workers in our country, they are actually coming from very poor backgrounds. They, I don't think, would have the kind of uh, I won't say skills, because I think domestic work is skill, but I don't think they would have the kind of uh, perhaps glamour that a platform worker is supposed to provide. Yeah, and I think we need to study the platformization of domestic workers and the extent to which it actually exists, even in big cities, because I think what we have is very anecdotal evidence. For instance, we did a survey of domestic workers about a year and a half ago in Pune, about 3,000 domestic workers from different parts of the city, and we didn't really come across any platform worker for that matter. Yeah, I think UA, through its different organizations, also has come out with a report, and there's not much in it about platform workers either. So yes, there is there is a segment, but I think it needs to be studied further before we draw more conclusions. So I think I'll stop there, and perhaps my fellow panelists will have more to say. Thank you.
Thanks a lot, Kiran, because you dealt with the issue of organizing, because that's a very crucial part of what actually the purpose of this webinar was, also to work out an action plan, not just talk about what the problems are, but actually concretely suggest ways by which we can all collectively come together at the national level as well as the state level. And approaching the Supreme Court or the High Courts is not the solution to the problem. So leaving that more for discussion with people, I'll just move on to Madhulika, who actually will now take up from where Kiran left with regard to platform work. Madhulika works with the Center for Labor Studies at SIU, provides advocacy and research support to workers and trade unions, including domestic worker unions. She's extremely knowledgeable. Both of us have worked together on many issues, and I actually ask her for suggestions on many issues. She's also a lawyer. She was recently involved in efforts to bring a domestic worker law in Karnataka. Yeah, Madhulika.
Gayatri flatters me. Thank you, Gayatri. So I'll first offer some context to platformization of domestic work before going on to speak about the law. It's a relatively new entrant to the gig and platform space. So understanding the lay of these domestic worker platforms becomes important before we look into regulation. So in India, at least in my reading, the platformization of domestic work, by which I mean the organization, coordination, and control of domestic labor through digital platform, is of at least 4 types and categories. The first is marketplace. So these are just intermediaries that connect the customer to the worker. You pay a fee to access the platform, and thereafter the customer directly pays the worker. So a popular example is Book My Buy. So I'm not going to belabor the point. Second is your digital placement agencies. So in this type of service, you have a company that plays a more central role in managing placements and worker-client relationships. Usually the workers are engaged with the agency, and agency takes a cut from the worker's monthly wage. A third category of platforms are surveillance platforms. So these are apps that are entirely geared towards surveillance in residential colonies and these high luxury apartments. A couple of examples would be the MyGate and the No Brokerhood app. And domestic workers who work in these high-rise buildings are forced to interface with these apps to notify and seek permission from residents every time they enter or leave the complex. So what these apps do is that they allow the employers to monitor the whereabouts of the workers when they've entered the residential complexes and as to when they leave. Residents also have the option of ranking domestic workers across different parameters, including attitude, punctuality, quality of service. And these are ratings that are essentially available to all other inhabitants of the buildings, but are not accessible to domestic workers. So domestic workers have no avenue to contest these ratings on these apps. The newest entrant, and I think by far the most popular entrant, and by popular, I mean something that's been in the news quite a bit recently, is the on-demand platforms, which is the fourth category of work in this realm of platformization. And usually when we think of the platform economy, we think of food delivery and transport, but we tend to forget that the urban services market is growing at a phenomenal pace in India. In fact, I would disagree with the previous speaker, but only with respect to my experience in Bangalore. Because what we see is that both Snabit and Urban Company are growing at an astounding pace. So even though their operations might not exist across the city, what they've done is that they've carved out different spheres of influence in specific areas, and they're slowly starting to build a monopoly in these areas. And there seems to be quite a lot of uptake for these apps, at least in Bangalore. But it's interesting to see how different these services are in different states. And when you look at Urban Company and Snabit, both of whom, by the way, have emerged as this kind of duopoly in the Indian market, they are different from the other three categories in the sense that they retain a very high degree of control over the labor process. And what happens is that it's not just your customer who has a say over the terms and conditions of the work, but it's also these platforms. And what is worse is that often these conditions are nebulous and vague. It's not as if the platform informs the worker, okay, these are your expectations. These expectations are made as and when the work continues. Importantly, though, I also have to mention, in contrast to an Uber driver or a Zomato worker, where we see the algorithm more involved in terms of their earnings or the access to work, algorithmic control is a bit lesser when it comes to domestic work. But nevertheless, it is present, it's significant, and it's something that needs to be studied. And from very anecdotal evidence and conversations that I've had, thanks to Geeta, in fact, what we found is, one, for all talk of flexibility that Urban Company offers, especially through his InstaWork, InstaWork services, InstaMade services that they called it, there's absolutely no flexibility because, one, they've introduced a slot model, which means that workers are required to book slots in advance, and they do not have an option of rejecting the bookings, right? So the orders are auto-accepted. So if a worker wants to cancel, the worker has to face a penalty. So it doesn't matter if the worker has a medical emergency or a family emergency, none of it is mattered. Once you're assigned a job and you cancel, you're penalized. So this whole myth and idea of flexibility that is attached to platform work, even in case of domestic work, in the platform sphere now, does not exist. Workers cannot modify their schedules while customers can. Customers can cancel last minute without having to face any significant penalty, but workers cannot, right? So this dynamic creates a significant power imbalance between the parties and exacerbates the power balance that already existed prior. Second, these slots that workers book on either Snabit or on Urban Company, they book it for a specific chunk of time, say 8 hours or 4 hours. But you are not guaranteed jobs during these slots that you choose. So you may either get a job or you may not. So your earnings are not for those 4 hours or the 8 hours that you're on standby. Your earnings are only for the gig that you are assigned. So you can be waiting for 8 hours to only get one gig and maybe just earn that 100 or 200 rupees that you get for that specific gig. What you're doing is essentially you're on standby and you're effectively losing the ability to make money elsewhere. Because if once you've agreed to be available during a specific slot time, you cannot take the chance of canceling a booking when it comes. So you have no choice but to stick to that platform and be on standby. Third, both Urban Services and Snabbit offer domestic worker services in Bangalore in 10 minutes, right? The 10-minute delivery timelines that you see for food delivery, the same is applicable even for domestic worker services for Snabbit and Urban Company. Actually, I was checking this morning, for Snabbit, it's 5 minutes. How is a worker supposed to reach a customer's house in 5 minutes unless you have a worker stationed in every corner of the road is something Snabbit and Urban Company has to answer. But what we can understand is that both the company and the worker know that this is an impossible promise. But what this impossible promise does is that it creates pressure on the workers. And like I mentioned before, and thanks to Geeta, who had actually spoken to several of these workers in the past 2 weeks, what she was telling us was that Urban Company and Snabbit have drawn their spheres of influence and carved out different areas in the cities where each of them work. So what they've done is create this kind of resting area, which is identified where domestic workers, again, Geeta mentioned that most of them were migrant workers, younger migrant workers, who gathered, and then they would be dispatched to different houses, right? So it's not as if these places where these areas where they congregate up, there's a proper structure, or they're well ventilated, or they receive drinking water, or have access to a washing room, resting facilities, anything, right? These are just informal areas where they congregate. Lastly, ratings is a very important, ratings determine how workers get access to jobs on the platform. They also determine, they determine how often you get a job, as a consequence of which it determines your earnings. And it's actually quite shameful to look at the kind of ratings that customers give on the apps. I was looking at a couple of I was looking at the Snabbit and Urban Company app this morning, and you see a number of casteist communal comments. Someone has written, no, you have sent a Muslim worker, never send a Muslim worker to me again. You also have several workers several customers casting aspersions on workers. Workers, it has to be noted, do not have the option of responding to this slander. It is just a one-way street where the customer reigns supreme and the worker has to take what is given to them. It's also the case that because ratings determine your access to work and your earnings, the domestic worker then is forced to show that they're more available, more amenable to get a higher rating. If you don't, then you face negative consequences. See, for instance, as opposed to all the other types of work on Urban Company, which are piece rated, you go for a specific task. Domestic work on Urban Company and Snabbit is time rated. So workers are not paid for a task, but for this time they spend at a customer's house. And during this time, the customers have the option of asking domestic workers to perform any task within the household. And informally, we've been told, when I'd spoken to 2 workers, they told me that, okay, I have no choice. No matter what they ask me, I have to do within that 1 hour. I will have to increase the pace at which I do it because I'm scared they'll give me a lower rating. It's not as if once I get a 4 out of a 5, the Urban Company will ask me, okay, what happened? And I can justify that, no, they asked me to work more than necessary. So as a result of which, domestic workers in the apps are at complete mercy of both the customers and the platform. Unfortunately, if you look at the laws that have been passed by different states, I'll specifically speak about Karnataka because I was involved in the process and know the law better. These platforms are almost an eyewash. They're genuinely not of much use. If you take the Karnataka platform law, for example, it does apply to urban services. So urban services, so both Snabbit and Urban Company will fall under the ambit. But the platform law does not provide any right to workers to receive a minimum wage. What the law simply says is that companies must comply with a fair wage and must ensure fair working hours. What is fair working hours? What is fair wages? None of this is mentioned either in the act or in the rules. How is wage calculated? Does your working hours include rest time? All of this is decided for the platform to unilaterally decide, right? Second, if you look at the Karnataka platform law, for example, workers do have the right to ask information from the platform about algorithms, right? Workers can say, okay, why am I ratings this way? Why have I received a 4.5? But they cannot challenge that 4.5 rating. So all workers, and also very smartly, and I think this is something that Geeta alluded to in the beginning, of how they've removed trade unions out of the process entirely. If you look at the act, they don't mention trade union at all. So only workers can seek information. Trade unions can't. It's impossible to expect a domestic worker to go to a company as big as Urban Company, put their job in jeopardy to ask them information about ratings, right? It's also complicated to understand it. This is something that a union should be doing, and a union should have a right to do, which is something the law doesn't provide. It is also, you can also terminate under the law. You also don't really have any protections against illegal termination. All that the act says is that worker has to be provided 14 days a notice in 14 days, and you have to provide a justification. It's not as if before the worker is terminated, there is a process, there's a fair process where the worker is given a chance to put their case across, right? And similar to the POSH Act, we have an internal dispute mechanism, which is management driven, that the workers can take their grievances to. But we all fully well know how the ICC has functioned under the POSH Act, to know that there isn't much we can expect from this internal dispute mechanism. But interestingly, we at NLS had some interaction with the government when the rules were being made. We were completely shut out of the process when they were drafting the law, the act, but we did have some conversations with the government while drafting the rules. So we were able to include a specific protection saying that for women workers, the POSH Act will apply to all gig and platform workers, so including domestic workers in Karnataka, which in my opinion is quite a significant victory. And when rules in other states for platform laws are being drafted, like Bihar, Telangana, Rajasthan, I think we should look at the Karnataka model and definitely ensure that the POSH Act is included, at least in the rules of the...
Madhu, you'll have to summarize because time is, sorry. I am
no problem,
sorry.
No problem. So just to put it in a nutshell, the regulation that we have, state level regulation that we have, even the ones that are in effect, are not of much use to workers. Geeta has already spoken about the Karnataka domestic workers law, so I'm not going to speak about that again. But yeah, I think I'll end my monologue here.
Sorry.
No problem.
Sorry. Just one sec, sorry. I've got thrown out. Yeah, sorry, I got thrown out. Thanks a lot, Madhulika. You gave a completely new angle to this whole debate, which is very interesting, and we need to have a discussion on this at more length separately and more in detail. So thanks a lot. I'm sorry for butting in and preventing people to talk, because every speaker has put in some very interesting and new points, but we are running short of time and we will not have time for question and answers, which is also an important part of this webinar, so that we can concretize something. And at the end, we need to just briefly say something on what we want, our proposals for an action plan. So we have the next very important speaker, which is Uday Bhatt, and yeah, he will be speaking in Hindi. Fortunately, because there was a message which said that please talk in Hindi. We're extremely sorry we were not able to translate, but at the end we will try to summarize some of the points which each speaker has made in Hindi. Uday Bhatt is the convener of the Maharashtra Rajya Gharelu Kamgar Samanvay Samiti. He is also the General Secretary of the Maharashtra Rajya Sarva Shramik Mahasangh, which is affiliated to AICCTU, and he's the Vice President of AICCTU. So he is very active, and he has taken up the issue of domestic workers. Uday, are you there?
Yes, yes, yes. फर्स्ट पहले तो एक वेबिनार आपने ऑर्गेनाइज किया, इसके बारे में मैं आपको धन्यवाद देता हूँ कि ऐसे समय पर एक डोमेस्टिक वर्कर्स जैसे एक अनऑर्गेनाइज सेक्टर्स के बारे में हम लोग विचार कर रहे हैं कि जब भारत की सरकार ने 4 लेबर कोड्स को, श्रम संहिता को पेश किया है और उससे जो वर्कर्स को राइट मिल रहे हैं वही खतरे में है। इस समय में हम एक बड़े अनऑर्गेनाइज सेक्टर जिसमें महिलाओं की संख्या ही सबसे ज्यादा है और वो इकोनॉमिकली एंड सोशल सेक्शन से भी वीकर है और उनको एक कानून के दायरे में लाने की चर्चा हम कर रहे हैं और आंदोलन भी कर रहे हैं। एक जगह जो हमारी सरकार है वो मजदूरों को कानून से बाहर निकालने की कोशिश कर रहे हैं और उसी समय में हम एक नए जो वर्क फोर्स है जो अनऑर्गेनाइज्ड है उनको कानून के दायरे में लाने की कोशिश कर रहे हैं। तो इसके बारे में वो जो अभी तो चर्चा हुई है, तो हमारा जो संगठन है वो 1980 से डोमेस्टिक वर्कर्स को ऑर्गेनाइज करने का हमें अनुभव है और मैं जो महाराष्ट्र में जो पहला कानून हुआ, महाराष्ट्र राज्य डोमेस्टिक वर्कर्स वेलफेयर बोर्ड एक्ट, उसके तहत जो ट्राइपार्टाइट बोर्ड था उसमें ट्राइपार्टाइट बोर्ड ओनली एग्जिस्टेड फॉर ओनली 3 years, 2011-2014। अभी तो 1 मैन बोर्ड है और उस ट्राइपार्टाइट बोर्ड में भी मैं मेंबर था। तो जो इश्यू अपने सामने है, ये जो ब्यूरोक्रेसी है या पॉलिटिकल क्लास जो है वो डोमेस्टिक वर्कर्स के बारे में कोई कॉम्प्रिहेंसिव नेशनल लेवल या स्टेट लेवल पे ऐसा डिटरेंट कानून लाने के लिए उनको तैयारी नहीं है कि उनको ऐसा लगता है कि ये अगर कानून लाए तो हमारी पॉलिटिकल कॉन्स्टिट्यूंसी विल गोइंग टू बी हर्ट। जो उनके जो एम्प्लॉयर है उनकी संख्या कुछ करोड़ों में है, लाखों में है। अगर देश के बारे में हम सोचेंगे तो ये हर एक घर ये इसमें आएगा और वो उनको ऐसा लगता है कि उनको तैयारी नहीं है, कि उनको ऐसा लगता है कि उसको पॉलिटिकली उसका जो एक रिपरकशन होगा उसके लिए वो तैयार नहीं है। तो सिर्फ ये महाराष्ट्र का जैसा जो छोटा कानून लाया है उसमें ठीक है कि रजिस्ट्रेशन मिला, कुछ छोटे मोटे फायदे मिले, मगर जो मेन डिमांड थी कि जो सोशल हमको जो चाहिए था, सामाजिक सुरक्षा जैसे कि पेंशन हो, मेडिकल कुछ असिस्टेंस हो या मिनिमम वेजेस हो, वर्किंग आवर्स हो और डोमेस्टिक वायलेंस के बारे में कोई ग्रीवेंस एक सेल हो, ऐसे कुछ बातें तो हुई नहीं है। क्योंकि तो उसमें प्रिंसिपल एम्प्लॉयर जो है जिसके घर में वो काम करती है, अगर वो कानून के दायरे में नहीं है तो कोई भी कानून हो नहीं सकता। दिस इज ओनली जस्ट विशेष, गुड विशेष कि ऐसा कुछ होगा। तो ऐसे में अभी एक नया भी प्लेटफॉर्म करते ये जो आए हैं, तो हमारे जो महाराष्ट्र में जो हमारे 35 घरेलू कामगार संगठन का हमारा जो समन्वय समिति है, उन्होंने हमें ये जो बुक माई बाई ने जो एडवर्टाइजमेंट किया था कि आउट ऑफ 10 एवरी मोस्टली 3 आर द पोटेंशियल क्रिमिनल्स, तो आपके घर में ये क्रिमिनल नहीं आए तो हमारे से आप दे दीजिए, हम लोग वेरीफाई करके देते हैं। तो उसके खिलाफ हम लोग ने तुरंत ही कदम उठाया कि 3 तारीख को हमारे पूरे डिस्ट्रिक्ट में महाराष्ट्र में हम लोग ने डेमोन्स्ट्रेशन किया। उसके साथ साथ चीफ मिनिस्टर, लेबर मिनिस्टर को भी हमने एक निवेदन देके कहा कि इनके ऊपर आप क्रिमिनल ये कीजिए, एक्शन लीजिए, उनको ये रेगुलर उनको कंट्रोल करना चाहिए, कुछ ना कुछ रेगुलेशन लाना चाहिए। उसके साथ साथ 21 जनवरी को हमने एक सेंट्रली मुंबई में एक बड़ा डेमोन्स्ट्रेशन भी किया था। इन उसके दरम्यान बुक माई बाई ने वो एडवर्टाइजमेंट हटा दिया है। तो अब एक ट्रेडिशनल से हम लोग जो डोमेस्टिक वर्कर्स है उनका एक बड़ा तबका है, उसके साथ साथ ये फास्टेस्ट ग्रोइंग अभी जो प्लेटफॉर्म वर्कर्स है वो भी हमारे साथ अभी एक नए तरीके से आ रहे हैं। तो मुंबई में या पुणे में तो मुझे ज्यादा एक्सपीरियंस है, पुणे मुंबई में वो बढ़ रहा है। तो उसका जैसा कुछ ये है उसका, तो उसका एक पॉजिटिव भी एक बात है कि उनको संघर्ष में या संगठित करने में भी हमको एक अपॉर्चुनिटी है कि उनको अगर संगठित करने में हम लोग कामयाब हुए तो मुझे ऐसा लगता है कि जैसे का मॉडर्न वर्किंग वर्कफोर्स जैसे उनसे डील हो सकता है। अब जो महिलाएं काम करने जाती है वो इंडिविजुअल लेवल पे जाती है, मगर एक कंपनी के थ्रू जाएंगी तो उसमें कुछ जो बातें हैं वो हमने सुनी है और वो बात सही है कि उनका किसके जाके उसको ग्रीवेंस करना है या कुछ करना है, उसमें ही गवर्नमेंट का रोल प्ले करने के लिए हम लोग अगर एजुकेशन खड़ा करेंगे अच्छा, तो उसको रेगुलेट करने के लिए मुझे लगता है कि ये हम गवर्नमेंट के सामने कुछ एक मैकेनिज्म को एक ये कर सकते हैं कि वो इनको रेगुलेट करना चाहिए कि ये अलग टाइप का काम है और इसमें आप एंटर होना चाहिए। तो उसमें वो रेगुलेट करने के लिए कोई अच्छा कॉम्प्रिहेंसिव कानून बनाना ये वगैरह हो सकता है। और बाकी का जो क्रिमिनलाइजेशन की बात है वो हमारे पास पुणे का बहुत बड़ा एक्सपीरियंस है कि हमारे पास एक 5-1 हजार डोमेस्टिक वर्कर्स के ऐसे केसेस है कि जिनके ऊपर मालिक ने कुछ चोरी के ऐसे आरोप लगाए थे। तो हमारा स्टडी ऐसा कहता है कि ऑलमोस्ट 96% केसेस में ये डोमेस्टिक वर्कर्स दोषी नहीं रहते, उनके घर का कोई आदमी रहता है या घर में कुछ काम करने के लिए कोई आते हैं कारपेंटर या समथिंग, उनके साथ वो लोग करते हैं और डोमेस्टिक वर्कर्स के पास वो लेते हैं। क्यों? बिकॉज ऑफ ये जो सोशल अपना स्ट्रक्चर है, हमारे जाति व्यवस्था भी है, महिलाओं को कम लिखना भी है, और उसके साथ साथ जो वो सोशल सेक्शन से आते हैं तो उससे यही और चोर भी गिर सकते हैं, ऐसा एक हो सकता है। मगर हमारा रिकॉर्ड ऐसा कहता है कि 96% में घर के लोग होते हैं और ये तो बात ऐसा ये हो ही नहीं सकती। और पुणे में हम लोग ने ऐसा किया था कि अगर कोई कंप्लेंट आए पुलिस स्टेशन पे तो हमारे संगठन को वो पुलिस स्टेशन फोन करते हैं, फिर हमारे एक्टिविस्ट जाने के बाद ही उसको पुलिस स्टेशन में लिया जाता है। उसको उसके साथ हमारा संगठन का कोई रहता है, उसके सिवाय उसको कंप्लेंट एंटरटेन नहीं करना है। ऐसा भी हमने एक मैकेनिज्म कुछ साल तक किया था। तो इसके सब देखते हुए हमें ऐसा लगता है कि हमारा जो समन्वय समिति की ओर से उसके साथ साथ नेशनल प्लेटफॉर्म डोमेस्टिक वर्कर्स से भी हम लोग जुड़े हुए हैं। तो एक से हम नेशनल लेवल पे एक कॉम्प्रिहेंसिव लेजिस्लेशन के लिए हम लोग ट्राई कर रहे हैं, उसके साथ स्टेट लेवल के अभी जो सुप्रीम कोर्ट ने बीच में 25 का जो जजमेंट दिया था एक उत्तराखंड के बारे में, तो उसको कमिटी फॉर्म की थी और कमिटी ने अनफॉर्चुनेटली रिकमेंड किया कि देयर इज नो नीड ऑफ एनी कॉम्प्रिहेंसिव सेंट्रल रिलेशन बिकॉज ऑल 4 कोर्ट्स आर टेकिंग ऑल केयर ऑफ ऑल द क्वेश्चन रेज बाय द सुप्रीम कोर्ट। बट वो ऐसा नहीं है। ये 4 लेबर कोड सब वेग है, उसमें कोई सोशल सिक्योरिटी के बारे में कुछ ठोस ऐसा कुछ दिखा नहीं है। तो उसने मगर एक उन्होंने एक रिकमेंड किया है ऐसा कि ये स्टेट के बारे में, अगर स्टेट ने अगर कोई इनिशिएटिव लिया तो ठीक है, स्टेट ने इनिशिएटिव लेना चाहिए, ऐसा उन्होंने एक स्टेटमेंट किया है। तो वैसा देखते हुए हमें लगता है कि एक कॉम्प्रिहेंसिव सेंट्रल लेजिस्लेशन के साथ साथ स्टेट का लेजिस्लेशन भी अच्छा हो, जैसा महाराष्ट्र में किया है, मगर उसमें कोई बड़ा डिटरेंट कोई जैसा ये मैकेनिज्म नहीं है। तो उसमें कोई अमेंडमेंट करना चाहिए, ये ऐसा आंदोलन तो है। अभी 10 मार्च को हमारा एक महाराष्ट्र लेवल का बड़ा एक डेमोन्स्ट्रेशन है टू अमेंड महाराष्ट्र स्टेट वेलफेयर डोमेस्टिक वेलफेयर एक्ट। उसमें प्रिंसिपल एम्प्लॉयर को भी इंक्लूड करे और हमारे जो डिमांड्स है वो करने के लिए वो हमारा हम कर रहे हैं। तो ऐसा मुझे लगता है कि ये प्लेटफॉर्म वर्कर्स जो अभी प्लेटफॉर्म जो खड़ा हो रहा है उसको भी एड्रेस हम लोग करना चाहिए कि जो भी धीरे धीरे वो बढ़ेगा कि जैसे जैसे वो जैसे जैसे ग्रामीण इलाकों में जैसे जैसे क्राइसिस बढ़ेगा, जैसे कि कृषि का हो या आदिवासी को डिस्प्लेसमेंट का जैसे जैसे बढ़ेगा, जैसे जैसे प्रोजेक्ट अभी जैसे आगे बढ़ेंगे तो शहरों की तरफ आने का ये और बढ़ेगा माइग्रेशन। और उसमें महिलाओं को 2-3 रोजगारी है। एक तो वो कंस्ट्रक्शन वर्क में जाए या डोमेस्टिक वर्कर्स हो या छोटे मोटे काम हो, तो डोमेस्टिक वर्कर्स में ये और लोग आएंगे तो पूरे देश से आएंगे शहरों की तरफ, तो उनको ऑर्गेनाइज करने के लिए हम लोग आगे बढ़ना चाहिए। और हम जो सब अलग अलग ट्रेड यूनियंस है उनका, जैसा हमें महाराष्ट्र में एक कोऑर्डिनेशन कमिटी किया है और वी आर वर्किंग वेरी स्मूथली, जिसमें कोई ट्रेड यूनियन का जो एक सेक्टेरियन जो होता है अनफॉर्चुनेटली वो वैसा नहीं है, कोई कोऑर्डिनेटेडली काम करते हैं हमारे हमारे एरिया में और साथ में लेके भी काम करते हैं। तो जहाँ जहाँ ये प्लेटफॉर्म वर्कर्स काम पे जाने के लिए इकट्ठा होते हैं, जैसे कि हमने मुंबई में स्टडी किया तो कुछ गार्डन में, पब्लिक गार्डन में सुबह इकट्ठा होते हैं, तो वहां जाके उनको अप्रोच करके धीरे धीरे उनको भी ये दायरे में लाना कि नाउ यू आर नॉट जस्ट ए इंडिविजुअल वर्कर, यू आर वर्कर ऑफ द वन कंपनी। तो कंपनी का वर्कर है तो अपने को यही है, आपको आपको मिलना ही चाहिए और उसमें गवर्नमेंट हैज अ इम्पोर्टेंट रोल टू प्ले। तो ऐसा कुछ हम खड़ा कर सकेंगे तो मुझे लगता है कि ये चैलेंज को हम लोग अच्छी तरह से एड्रेस कर सकते हैं। और अंत में इतना ही मैं बोलना चाहता हूँ कि ये करोड़ों की संख्या में ये महिला ये है, मजदूर है, तो हमें भी मजदूरों का अधिकार मिलना चाहिए, श्रमिकों का। इसके बारे में अगर हम लोग आगे बढ़ेंगे तो बढ़ने का स्कोप भी ज्यादा है। तो हम इकट्ठा होके ज्यादा से ज्यादा, जितना ऑर्गेनाइजेशन है उनमें ज्यादा से ज्यादा इकट्ठा होके अगर हम लोग ये लेंगे सवाल तो आगे बढ़ेंगे। महाराष्ट्र उसका एक उदाहरण है। अभी कर्नाटक में भी हमने देखा है कि आपने ये जो एक नया कानून बनाया है गिग वर्कर के लिए, तो महाराष्ट्र भी एक ऐसा उदाहरण है कि एक सालों के साथ आंदोलन के बाद कानून करने वाला पहला स्टेट था। तो उसमें खामियां है, कुछ बातें भी कम है, मगर आगे बढ़ेंगे हम लोग एक एक एकजुट से, ऐसा मुझे लगता है। ठीक है,
थैंक यू फॉर गिविंग अ पर्सपेक्टिव कि ऑर्गेनाइजेशन लेवल पे हम लोग क्या करना चाहिए उसके ऊपर। लास्ट अपना जो स्पीकर है वो है रीता दास। शी इज डोमेस्टिक वर्कर फ्रॉम जोरहाट, असम, and she has been active working amongst domestic workers and is the president of the गृहकर्मी अधिकार सुरक्षा समिति। रीटा, आप आर यू देयर? हेलो।
हेलो।
हाँ बोलिए।
हाँ मैं सुन। हाँ, हम लोगों का यहाँ दरअसल मुझे इतना हिंदी नहीं आती है, जितना हो सके हम बोलते हूँ।
हाँ बोलिए। सॉरी, हमको बंगाली नहीं आती है,
हाँ
असामीज नहीं
मुझे।
आता है, असामीज। तो
हाँ
आप बोलिए जो भी टूटा फूटा हिंदी में।
हाँ हाँ, हम लोगों का यहाँ दरअसल समस्या ये है, जो मतलब कामगारों का साथ मतलब पैसा नहीं मिलता है। जो चोरी का जो किसी ने किया उसको मतलब हम लोगों को, जो हम लोगों को गृह कमरी के साथ ही वो हो जाते हैं, मतलब वो ही किया है ऐसा बोलते हैं। तो हम लोग का जो गैस है वो उसके तरफ से हम लोगों को ये जितना हो सके वो सब मतलब हम लोग ठीक करते हैं यहाँ। मतलब दरअसल बात समस्या जो वो है, पैसा नहीं मिलता है लोगों को जितना मिलना चाहिए, और हम लोगों को जो और ये है पैसा नहीं मिलता है, और जो हम लोगों का जो मतलब वो आयन आना चाहिए वो आयन जो आ जाए तो बहुत अच्छा होगा हम लोगों को लिए। और हम लोग भी अब गुवाहाटी में मार्च 7 मार्च को जब हरी एक संगठन जो हम लोग जोरदार एक क्या कहते वो, मतलब हम लोग मैम को मैम बोल देंगे। हम आसामीज में बोले, आसामीज में बोल सकते हैं क्या?
हाँ हाँ, रीता जी आप बोलो। कोई आपके साथ है ट्रांसलेट करने के लिए?
हाँ हाँ, ट्रांसलेट करने से है हमारा मैम।
है
ठीक
तो
है,
फिर
ठीक है।
हाँ उनको बोलिए, आप
हाँ हाँ
असामीज में बोलिए और उनको बोलिए ट्रांसलेट करने के लिए।
हाँ 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 ठीक है। वो यहाँ लाइट चली गई। दरअसल हम আমাৰ ইয়াত বহুত কামবোৰ হৈ আছে। ধৰক সমস্যাবোৰ হ'ল যে আমাৰ গৃহকৰ্মীবিলাকে সন্মুখীন হৈছে, যিবোৰ মানে দৰমহা কাম কৰিও দৰমহা নাপায়। দৰমহাটোৰ ক্ষেত্ৰত কিছুমানে ধৰক পইচাৰ ক্ষেত্ৰত পইচা নিদিয়ে, আৰু আমাৰ ইয়াতে যিবোৰ মানে কাম কৰিবলৈ মহিলাসকল যায় সেইবিলাকৰ চুৰি কেছতো ফচাই দিয়ে। তো তাৰ বাবে আমি আন্দোলনো কৰোঁ বহুত, যে এইবোৰ আমাৰ সমাধান হ'ব লাগে। তাৰপিছত আমি এতিয়া গুৱাহাটীৰ 8 তাৰিখে এটা আন্দোলন কৰিবলৈ গৈ আছোঁ, বহুত ডাঙৰ। এইটো আমাৰ মানুহখিনি ধৰক বহুত 100-150 মান আমাৰ ইয়াত হেৰিৰ পৰাই যাব, যোৰহাটৰ পৰাই যাব গুৱাহাটীত। তো আমাৰ সমস্যাবোৰ সেইবোৰ হ'ল, আৰু আমাৰ বহুত কামো হৈ আছে। ধৰক যিবিলাক আমাৰ গৃহকৰ্মী মানুহবিলাকৰ এই গোট খুৱাওঁ একতা, আমাৰ যিটো হেৰি হয়, এই ধৰি মই নাৰ্ভাছ হৈ গৈছোঁ অকণমান, ইমান হেৰি। তাৰপৰা আমাৰ যিখিনি মানে কমিটি
Oi,
মেম্বাৰ মানুহখিনি আছে।
Ishita,
হয়
can you
হয় মেম।
translate?
Yes, I
Ishita?
am translating in the chat box.
Oh, very good. Okay, okay. हाँ बोलिए बोलिए, अभी कोई है
हाँ
ट्रांसलेट कर रहे हैं वो।
हाँ हाँ करेगा। तो हम लोगों का समस्या वो है, मतलब जितना हो सके उतना हम लोग महिला को इकट्ठा करके ये बोलते हैं कि ये करो, ये हो सके तो हमको गैस के तरफ से बहुत सुविधाएं मिलता है। समस्या को समाधान करने के हम लोग को समझाते हैं, जे ये करो, आप लोग ये करते हैं, ये से ये करो। तो हम लोग मतलब सब एकजुट हो के जितना हो सके वो मेमोरेंडम भी दिया है हम लोग कोर्ट में, जे हम लोगों का जो आइन हो सके वो असम में भी लागू हो। जो हम लोगों को मतलब सुविधाएं है वो सुविधा हम लोगों को मिले, जो हम लोगों को नहीं मिल रहा है। जो हम लोगों का हफ्ता में 1 दिन छुट्टी चाहिए, और जो मतलब जो न्यूनतम मजदूरी हो वो मिल सके, और हम लोगों का जो मतलब सम्मान हो वो सम्मान हम लोगों को मिल सके। एक प्लेटफॉर्म हो जहां हम लोग सब बोल सके खुल के, ऐसा हम लोग चाहते हैं। और हम लोग का जो आइन है वो आइन गृहकर्मी अधिकार सुरक्षा समिति की तरफ से, मतलब जो आइन जो सरकार लागू किया है वो आइन हम लोग को मतलब जो होगा तो मतलब हम लोगों को जो समस्या है वो दूर होगा, मैं सोचती हूँ। और हम लोगों को तरफ से मतलब हम लोग पूरा जोर देते हैं कि ये महिला को जो मतलब कामगारों के साथ ये जो समस्या होते हैं वो समस्याएं जितना हो सके हम लोग कम करें। जो मतलब ये दूसरों के संगठन में जो लोग जाते हैं काम करने के लिए, उनको कभी पैसा नहीं मिलता है। हफ्ते में करके व महीने में हो जाए या छुट्टी ले ले या कुछ हो जाए तो उन लोगों को काम करने के वक़्त छुट्टी लेना पड़ता है, वो भी पैसा नहीं मिलता है किसी की तरफ से। मतलब वो हम लोग जाके वो पैसा दिलवाते हैं। और हम लोगों को जो औरत है वो हम लोगों को जो वो जो मतलब कमिटी मेंबर है उन लोगों को बोलती हूँ जे ये हो गया है, और हम लोग वो समाधान हम लोग खुद मतलब ये गैस की तरफ से जो सम मिला के हम लोग को शरी करते हैं। और जितना हो सके मतलब हम लोगों को सकते जो लोग इकट्ठा कर सके, लोगों को इकट्ठा कर सके, मतलब रजिस्टर कर सके, हम लोग जितना हो सके हम लोग इतना कर सकते हैं। और हम लोग वो जो 7 तारीख को जो हम लोग गुवाहाटी में जाके जो धरना देने के लिए हम लोग तैयार है, वो उसीलिए मतलब हम लोग को लोगों को कह रही है कि ये करना जरूरी है, तब हम लोग सरकार सुनेंगे हम लोगों को बात, जो हम लोगों को कहना है, हम लोग को जो चाहिए वो सकते हम लोग मिल सके।
Thank you. This Ishita, are you going to translate it or have you put it in the Ishita?
Yeah, I have put it in the chat box.
Okay.
One can see they are she's mainly talking about lower wages and leaves weekly leave, 1 day leave in a week. They are going to organize a dharna in Guwahati on 7th, where they are raising these demands to the government, to the state government.
Okay,
So
good.
they have to be united, they feel, but it is difficult to organize and unify all the domestic workers. These are the main points, but I have
Yeah.
written it in the chat box.
ओके थैंक्स ईशिता थैंक यू अभी हम कंक्लूड करेंगे क्विकली कुछ क्वेश्चन है तो हम ले सकते हैं एक दो और फिर वो कंक्लूजन सिद्धार्थ करेगा एक्शन प्लान के बारे में हमें आगे क्या करना चाहिए if there's any questions I see one hand Marina are you
Yeah,
coordinating
basically
it?
एक ही या नहीं I think
हेलो
chat box में हाँ मृदुला
हेलो हाँ
हेलो
हाँ मैं जो हाँ रीता जी ने जो असमीज में बात कर रही है वो हाँ इसी का ट्रांसलेट कर रही है उनका फर्स्ट टाइम ऐसा वेबिनार में ज्वाइन करेंगे इसलिए वो बहुत नर्वस हो गया है तो मैं कुछ ज्वाइन कर पाऊंगी क्या हेलो
मृदुला जी नॉट नीडेड अभी क्योंकि
हाँ
ये
Yeah.
ईशिता जी ने ऑलरेडी ट्रांसलेट किया है
वो
चैट बॉक्स में ठीक
हाँ
है
हाँ हाँ
वो
ओके ओके
वो ट्रांसलेट हो गया
हाँ ठीक है ओके
okay. Kiran has one hand up. Some Kiran Thakre.
एक सवाल है चैट बॉक्स में गायत्री जी
Yeah, बोले.
एक है the Supreme Court judgment on minimum wages does feel like a betrayal. My concern question is what will be the far-reaching implications of this for any future legislative and policy efforts at the national and state level. It does not set a good precedent, and it may take a lot of case law to shift the stand with this judgment. Also, would love to have a legal perspective from Advocate Gayatri and other lawyers? And also, what is your advice to unions here on approaching the Supreme Court? गायत्री जी वो आपके लिए सवाल है
मैं शॉर्ट में बोलती हूँ इंग्लिश में सॉरी
हाँ
that this whatever judgment that Justice Suryakant has given is absolutely contrary to earlier judgments that have been given by the Supreme Court in many cases. We can start from 1982 when the PUDR judgment was there, where the court went beyond the existing law and said that that certain directions were issued. Similarly, on prison rights, the Supreme Court has issued directions from time to time saying that under trials should be released, conditions of prisons inside, what are the implications of under trials as far as health is concerned. All these guidelines have been set by the Supreme Court. Similarly, on health issues, on workers' rights, on the issue of silicosis, the Supreme Court has set out certain guidelines directing the government to frame rules pertaining to medical treatment of workers who are suffering from silicosis. Then you have Vishaka, which is the most famous of all the cases where the Supreme Court set guidelines on Vishaka. Then you have the thing of the Vahini case where on the issue of honor killings, the Supreme Court set out certain guidelines. So you have umpteen number of such cases where the Supreme Court has intervened under Article 32 and 141. Article 141 basically says that the Supreme Court, whatever orders that are passed by the Supreme Court becomes the law. So I just feel that we should keep on bombarding. Maybe not in this case. We have to adopt different strategies by approaching the government, taking out campaigns, taking up this issue about the conditions of domestic workers, making it a public issue, campaigning, etc. And that should, of course, be the forefront of whatever we do. At the same time, to explain what, like, for example, whatever efforts that are being made by Karnataka, by the organizations in Karnataka, in Tamil Nadu, let us learn from each other's experience and see what we can do in terms of taking suggestions from those organizations at the state level and making it more taking it up at a national level and saying that this is what the Supreme Court has done is not correct, that the courts have the power to issue directions. And and we can give examples of that, and that the government cannot just sit back and say we have we have a legislation, we have the four courts. That is not correct. So explain what the law is today, what it lacks, and what we can do. And I think that we have to adopt different strategies. How to adopt it, that we have to strategize. Anyone else? Geeta, if you want, Geeta is there, lawyer. Any of the speakers want to say something on this? No? Then we'll just we'll end the thing because it's quite late with the last session by Siddharth.
Yeah, actually, Gayatri, I think Siddharth had to leave. So
Okay, then
just do one thing,
Marina.
and हाँ, तो
yeah.
actually मीरा का भी एक सवाल है यहाँ पे about how the domestic worker unions can push opposition political parties to take a public stand, and I think the Lawyers Collective has done this, correct? But
Yes.
also, just the reason I'm bringing up this comment here is because one of the things we thought at the end of this webinar is we have collectively as WPC, Siddharth had actually drafted this this letter to the one second to address to the Prime Minister, asking for a legislation on domestic workers, central legislation on domestic work. I've shared it in the chat here. If those who are remaining, there are around 54 participants. If you all can just take a look at this, any comments, any thoughts on it, even later, we are happy to have it. One is if we can endorse a public statement calling for a legislation and address it directly to the Prime Minister, because he is the head of the executive, and really right now, is it even worth approaching the CGI, etc.? That is one thing. The other point that a lot of the speakers have made is that yes, there are so many unions, इतने सारे unions है all across India, और आज के webinar में भी बहुत सारे लोग नहीं आए हैं जो शायद किसी और webinar पे आए हैं. बहुत स्टेट से भी लोग नहीं हैं, तो इज देयर सम वे इन विच एज WPC वी कैन मे बी कलेक्टिवाइज ऑल द डोमेस्टिक वर्कर्स यूनियंस जो अलग अलग स्टेट्स में काम करते हैं एक कॉमन प्लेटफॉर्म में जहाँ पे कॉमन जो सेंट्रल इश्यूज हैं, एंड वी कैन ऑल्सो लर्न, क्योंकि आज के वेबिनार से इतने सारे एक्सपीरियंसेस तमिलनाडु, कर्नाटका, असम से इतने सारे वेरिड एक्सपीरियंसेस आए हैं. तो वन इज अ रिक्वेस्ट कि एज WPC वी कैन कलेक्टिवाइज द डोमेस्टिक वर्कर्स यूनियंस एंड हैव a common platform because these issues are really growing. And the second thing is we can collectively, मतलब ये जो public statement है, can we endorse it individually as organizations, as unions, ये वो. It is just a letter to the Prime Minister asking for the need for a central legislation on domestic work. So these are just the two points that we would like to conclude with. If anyone else from the audience also wants to come in and has some thoughts on how we can move ahead, please share, because this is an open forum. It is a WPC organized webinar. So please feel free to come in and share your thoughts.
Kiran, you have something, a message on the group.
Yeah, they have already done so, but then, I mean, so many of us were not part of it. So, that's the point I think you were also making, Kiran, on the fact that everyone also is working in silos. Is there any other option? And Meera, you're saying to write to the CJ too. Yeah, sure, we can do that.
My opinion is that we need to actually take this issue to the grassroots. We as organizations, as representatives, we are doing this. But how many domestic workers actually know what the CJI said? I think there has to be some public campaign in the domestic workers.
Yeah.
And that has to be a mass level campaign. If we are approaching the I agree with Meena. What's the point of going to Modi? But I think we need to bring draw the attention of the CJI. I mean, how can he say this? I think somewhere we need to sort of point out to him through a public campaign. And I think if we can frame a signature campaign or something that can be part of a public campaign and take signatures and then send it to him. I mean, these are very gisapita, I would say, forms. But these are the ones that one has to fall back upon, because unless you involve people and sort of create an awareness in them, these guys are not going to move. I mean, they haven't moved for so many years after so much of persuasion. And I think the class consolidation is just getting more and more sharper. So, I'm not surprised that we got this kind of an order from the CJI. But I think at the same time, we also have to hit back, don't we? That's
Yeah.
my point.
So, okay, so this letter then definitely, I mean, if collectively we are feeling addressed to the CJI as well as to the Prime Minister, that can be done. But I mean, is there agreement that this letter needs to go? Or is there a feeling that this has already been done?
I mean, I haven't seen your letter, so I mean,
it's
we'll
there.
have to
We put
see
it on
it.
the
Yeah,
chat.
we'll have
Yeah,
to see
yeah.
it. But with
Wait,
the
wait.
letter,
And it's not my
can
letter, it's a letter
no,
that
no,
is
your letter in the sense whatever you put up, I haven't seen it. So we'll have a look. I just think that you need to translate it into different languages. You need to put it out as a public statement. I mean, all organizations can send this letter. It won't make any time difference to them. This is what I feel. No, I think we have to have some kind of a public expression at the end of it.
Yeah. I agree with Kiran. Actually, a lot of, at that time when it was very hot and burning the issue, a lot of lawyers groups, Najar, ILAJ, our union all over in Delhi and here in Karnataka, we've already done that bit of responding and putting it all over all the newspapers and all the public media, everything. Now it is over. I mean, that phase is over, but the indignity that came out of it and relating it to the whole labor codes, being alerted to the labor codes and the way they are, the way they are developing, evolving over the picture, and how the labor codes and the trade union, because even the massive trade unions also had a massive protest related when the CJA statement came out, but there most of the trade unions concentrated on the fact of the trade union being, the trade union forming a trade union being attacked. But they didn't take up, many of the organized trade unions also did not take up the focus on domestic workers in that. So, by repeating that now, I don't think it has much mileage, but taking it and discussing it among all our people to bring out the issues that is happening within the mindset of whether the judiciary or whether the employers or whether the government, and how much our system is threatened, how much the domestic workforce is entirely threatened by this kind of neglect, by this kind of arbitrary statements, arbitrary laws. I think we do need to do that.
Can I add something that it's just not a letter to CGI, but also I don't know if organizations have done that, but the committee's report, which basically said ABCD, should we not give a much more analytical critique of it, which could be translated in different languages and distributed amongst workers, as Kiran is saying? I agree that we need to reach out to the workers. So how do we do it? And also to make this issue a public issue, to say that this is not what I mean. The committee, which consists of government officials, are saying that they are nicely protected, they have so and so schemes. All these schemes are rubbish schemes. So can we like collectively do a critique of what the committee has said and give our analysis in brief? as to what should be done and what is the manner in which a national legislation can be enacted, what should be the ingredients in it. We don't have to frame the law as it is, but the basic requirements as far as fundamental rights are concerned.
I think that's a very good idea. And I think, the first point that we need to make is that you didn't invite a single trade union,
Yeah.
Yeah.
I mean, you didn't even put out, this is not how a committee functions. You didn't even put out an advertisement saying that, you were
Actually, the entry point is one, Kiran. But even after they very secretly and very late, they formed the committee and then they even brought out a report in no time, a report which is not even transparent, which is not even known to many people that actually they wrote a report. And a report that contains, anti.
Yeah, and I'm surprised that there are certain people on that who have put their signature to it, who are otherwise known as sort of labor experts or whatever.
So the entire thing is kept under such secrecy, and then they say all over that they actually sat, brought out a report, they did their job, finished.
I wonder if they did.
So we need to expose that.
Yeah, I agree. I think we can have a common I think we can have a common letter definitely to the committee.
Yeah.
Geeta, good evening, ma'am. Shall I talk to tell one or two points for the domestic workers? Geeta?
Is it related to the next steps?
We are.
I am Tara from Tamil Nadu.
Yes. We are discussing what should be done. So, any suggestions on that?
Yeah, we are the National Domestic Workers Platform is going on the month of March. We are going to see the standing committee members. Then we planned each states are trying to get the legislation. Each states in Tamil Nadu we filed the PAL. Then Bihar also filed the PAL. Each states are trying will get the state legislation. But we are trying to national legislation. Still, we didn't get it. So we are trying to state legislation. Then the Supreme Court told the union only make a problem between domestic workers and employers. It is very, very, very bad situation. So we will ask.
So what we would suggest is, yes, that Supreme Court judgment is something that has to be condemned. But if you could share whatever.
How can we proceed that condemn to the law to the judge? We want all the whole India. We want to condemn to the judge. Each state take some steps, send it the postcard or any signature campaign. It is better. One group is make it and prepare all the things. Then you send it to all the groups. We will send again to the judge. It is very.
Yes. So what we can do is all the participants who have participated in this webinar, we will be in touch with them and people who are doing work in their different areas to exchange information and also collectively what we can contribute to, we will do that and share it with everyone. But we will have to conclude this meeting now because it is beyond the time. Yeah. So thanks a lot.
Okay.
Yeah, thanks a lot for everyone's participation. Sorry for abruptly closing it. There's been a lot of debate, but we will be in touch with everyone and try to take it forward. Of course, everybody else is working in their own areas, which is any support or anything that we can give, definitely we will give. Thanks a lot.
Thank you.
Bye. Bye. Bye.
Thanks and bye. Very good.
Bye.
Bye. Thank you.
Okay, bye. Thank you, everyone.